Mr. Moore.
Yeah.
Yes. Let's not shout at people. Let's not raise our voices. Here's the thing. If an attorney is telling you what the state is offering, all you have to do, if you don't want to accept the offer, just say you don't want to accept it, say you want a jury trial, and you'll get a jury trial. But your attorney can't make the state offer you something that you want them to offer you.
It's not what, no. So it's not what they offer me, it's what you're lying on and trying to give me. And I know what I did. It was an argument.
Okay, so
It was
here's
an
the
argument. It was an argument. It was
then
an
it
argument.
means you need a jury trial. That's what you're saying. You want a jury trial.
Argument. It was an argument between me and my relatives.
All right, let me ask you, who's the
You
prosecutor on
started
this
adding on
case?
extra names onto the case. He added extra names on the, wait a minute. You're talking to me. You're talking to me.
Are you the prosecutor on the
You're
case?
talking to me. You said John, you just said John Moore,
Are you
right?
planning on dismissing these charges? All right, so it sounds like they're gonna want a jury trial. Are you planning on offering something different than you've already offered? All right, so is your client going to accept anything or no?
He has just informed me, we talked last night, but he informed me this morning because of some of the particulars, he's not going to accept the agreement.
All right, so nothing will, it sounds as though you all are at an impasse. The state, you're saying that you're not gonna offer anything differently. And defense, I'm assuming there's no counter offer, right?
No, at this, I did, I made a counter offer to the state and they rejected it.
All right, so do you have all of the discovery?
I do have all of the discovery, if I could, the one thing with moving forward, and it started last night with these outbursts, I'm starting to have potentially some competency issues. I want to stop and pause before I make that decision, but I think I'll need to file a suggestion or motion that he needs to be evaluated for, I really can't communicate with him right now, Judge. And that's part of what I have to do to make sure he's competent.
All right, so is the communication issue, and I don't want to interfere with attorney-client privilege, but is the communication more of he's not accepting your advice or you don't believe he understands?
Sometimes I don't believe he truly
I didn't
understands.
understand, I would not respond.
Okay,
For one, don't insult me. If
All
I
right.
did not understand.
All right, he can
don't
be
insult me,
excused.
though.
Thank you.
Don't insult me.
All right, can we set this for a jury trial?
You're ganging up
What
on
day?
me. I'm going, but don't insult me, sir. So if I do not understand the case, I would not respond. You understand that?
Yeah.
Today is.
So let me just tell you, today is Monday. If anybody thought today was not Monday, let me just tell you, today is Monday. Yes,
And I just started seeing this last night.
okay.
And I understand, I don't know when the court's gonna reset me. I would have to file a motion at this stage on the competency issue, Your Honor.
I would have no objection to that because I've had those concerns myself since I reviewed this case.
All
Well,
right,
and it's, for me, I hadn't seen it yet, but I saw it last night for the first time.
Yes.
all right. Ms. Ferguson, they're gonna file a motion to have him evaluated for competency. And I will say, this is the first time I've seen him be this way since he's come to court, so.
Same with me.
All right, so what we'll do, Norma, if you can set this for the second week in December, and that's to make sure that everything has been filed.
I can do December 11th.
I will follow it this afternoon, and December, the second week of December is perfect for me. I live to snow ski and I'm gonna open it this year, the first week of December.
Okay,
So thank you, Your Honor, for that.
you're welcome.
What unfolded in front of Judge Boyd was a hearing that started as a plea negotiation and quickly became something far more unsettling, a window into a defendant whose grip on the proceedings appeared to be slipping in real time. Mr. B arrived in court facing criminal charges stemming from what he described as an argument with relatives. His defense attorney had communicated a plea offer from the state. Mr. B rejected it. A counteroffer was made and also rejected. On the surface, that's a normal impasse, set it for jury trial and move forward. But this was anything but normal. The defendant began shouting out of turn, accusing his own attorney of lying, demanding to know if the prosecutor planned to dismiss charges, and seemingly unable to follow the basic flow of the proceeding. His attorney revealed that the outbursts had started the night before and that for the first time, he was genuinely questioning whether his client could understand and meaningfully participate in his own defense. That's not a small flag. That's the legal system's equivalent of a red alert. Both the defense and the prosecution acknowledged the concern. Even Judge Boyd noted it was the first time she had seen the defendant behave this way in court. With that alignment across all parties, the decision came swiftly. A competency evaluation would be ordered. The case was reset to the second week of December to allow the motion to be filed and the evaluation to be completed. Competency isn't about guilt or innocence. It's about whether a person can understand the charges against them and assist in their own defense. Without that foundation, the entire legal process, trials, pleas, sentencing, cannot move forward. This case is far from over. And the most important question now isn't what happened in that argument. It's whether Mr. B is legally capable of answering for it. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.